If you'll please state your name, who you represent, and your position on the bill.
Yes. Good evening, Madam Chair, Mr. Chairman, and committee members. My name is Laura Tamez. I am a private lawyer in San Antonio, Texas. I am also TTLA's Vice President of Communications, and I am here speaking on their behalf against the bill. I first want to start out by saying that we've appreciated the opportunity to work with Representative Sheets as well as have discussions with proponents of the bill, including the Civil Justice League as well as Ford. I understand that it was the substituted bill that was laid out today. We had been advised, however, that the bill was going to be laid out as written.
Madam Chair.
Mr. Sheets.
Just for clarification,
Yes.
This is a substitute that's alleged counsel rewrite of the original bill. There is another substitute to come, so the substitute that you're talking about has
Yes.
not been laid out yet.
Understood.
Okay.
Thank you for that,
Yes,
Representative Sheets. So with that said, we still intend on working with Representative Sheets and the proponents in working out whatever the substitution is. I look forward to seeing it. However, being as it is laid out, I still want to bring forth some of the issues and some of the concerns with this bill. So CPRC 71051 does not need to be amended, and here's why. Let me start out by saying that under CPRC 71031, that is a statute that comes before 051. That statute allows a resident or a non-Texas resident to maintain a cause of action for personal injury and or death, even if the act or omission did not occur in the state. So that just confers the jurisdiction. Then you've got 051 that says, okay, if someone from a foreign country, because 031 allows someone from a foreign country or from Oklahoma or Michigan, another state, to bring a cause of action even though the accident didn't occur in Texas. Once that happens, then the defendant has the option under 051, under forum non-convenes, to file a motion challenging the convenience of the forum. At that point, the trial court under the current statute has a mandate to go through an analysis. And that analysis is, I can state all the elements, but it's in the statute. But the trial court basically has to determine, do we need to have, is there a more appropriate forum for this case in the interest of justice and for the convenience of the parties? So as the amendments have gone through on these different amendments to 051, now we have trial court, you're mandated to go through the analysis. More importantly, the defendant has the burden to show that, to prove in this analysis that an alternate forum exists to try the case. There's an adequate remedy in the alternate forum, that an alternate forum can exercise jurisdiction. The trial court also has to balance private and public interests. For example, is there access to proof? Is there compulsory process for attendance of witnesses? Is there an enforcement of the judgment in this alternate forum? Also, within our current statute, the court has to look at the extent to which the injury or death resulted from acts or omissions that occurred in Texas. So they still have to look at, hey, is there any connection here? It's not just anybody can sue and then move forward. The other important part of our current statute says that a stay or dismissal, let's assume that the case is dismissed, cannot cause duplication of litigation or proliferation. In other words, more. Finally, it is mandatory that if the factors weigh in favor of an alternative jurisdiction, then the court is mandated to decline the exercise of jurisdiction in the state of Texas. So the trial court essentially is given the sound discretion. However, there's checks and balances. If there is a clear abuse of discretion, the appellate court can review it, as we have seen in some of these cases, as well as the Supreme Court. There was also an amendment where the trial court now has to give specific findings of fact and conclusions of law, so we can know what were they thinking, what did they review, what connections were there. But I think what's important to point out here, based on what some of the witnesses have said, is that each case turns on its own facts. There's not one size fits all. So, for example, one of the witnesses brought up that in the In re Ford, the facts is laid out when the court reviewed the language of the statute. That was bad facts for the defendant, and the plaintiff could maintain the cause of action. But in re Pirelli, same statute, court reviewed it, and in that case, it was bad facts for the plaintiff. So it's not like a plaintiff is gaining an advantage over a defendant or vice versa because of the way that the statute is laid out. The trial court can look at affidavits. There's got to be evidence. There's even some discovery that they have to go through. Now, what about this Texas resident provision? When we look at the Texas resident, what we call the safe harbor, where under the current statute, Texas residents, they don't have to prove their residency, first of all, but Texas residents, basically, the court may not state or dismiss the plaintiff's claims if you're a Texas resident. So the issue comes in when you've got a Texas resident mixed with a non-resident. At that point, the statute indicates that as long as there's proper joinder and there's a single occurrence, then the case can move forward and can't be dismissed. Now, in this analysis, Ford, whomever it is that has filed the form non-conveniens, can attack plaintiff's residents. They can attack whomever, if it's the intervenor or the next friend or it's JT or whomever it is, under the current statute, they can attack it and say, you know what, JT or Yuri in the Ford case, the adult child, she adopted a residence in bad faith. And the trial court has to look at that. That provision is really a safe harbor for defendants because the trial court has to review if the defendant brings forward bad faith, whether they adopted a residence improperly or they became a accepted personal representation improperly in bad faith, then the court has to look at that. So there's 3 safe harbors of bad faith provisions that are already exist in our statute.
Madam Chair.
Mr. Sheets.
Thank you, ma'am. Is it Tamez?
Tamez.
Tamez, okay. Thank you, ma'am. All right, so you talked about the balancing test,
Yes.
but wouldn't you agree that the balancing test goes completely out the window under subsection E once someone claims to be a legal resident and it's established they're a legal resident? There's no more balancing test, correct?
Well, but the legal residency has to be attacked.
Right, but once they say that they're a legal resident, then burden shifts to the defendant to prove that they're not a legal resident, right?
Correct.
So as soon as they claim legal resident, the balancing test goes out the window, right? It's no longer an issue of the balancing test, it's an issue of whether or not they're a resident, correct?
Well, I will say this. There's a balancing test that has to do with a bad faith provision.
No,
If there is a-
let's talk about the original balancing test first. That balancing test goes out the window, right?
But at what point?
As soon as they claim resident, the balancing test goes out the window, and the question becomes whether or not they're a resident, right?
Well, there's 2 balancing tests, with all due respect.
Okay.
The first one would be, are they even a legal resident? You can attack it and say they've adopted residence.
Right, and I
bad
get
faith.
that. I get that. We'll get there in a second. Let's
Okay.
talk about the first balancing test. First balancing test is if someone's going to attack form, they'll go through the balancing test, except for if they apply subsection E and say I'm a resident. Then that first balancing test goes out the window and the question becomes residency, correct?
Correct.
Okay. And the definition of resident begins with legal resident means an individual who intends the specified political subdivision to be his permanent resident. Correct?
Well, and
And it goes on, I'm not trying to hide anything, it goes
I
on.
understand.
I just don't want to read the, because I've already read it to the committee once, but it goes on, right?
It goes on under pursuant to the Texas Election Code, Section 1.015.
Okay, where is it set out in the statute?
There is a case that interprets the statute, the Owens Corning case. It's
Okay, so it doesn't interpret this definition right here?
It does, and it says this definition is linked back to the Texas Election Code.
Okay.
Yes, and so there, you're right. I mean, who intends to return to the specified political subdivision. That's correct. And the
It doesn't just say return. It
Yes.
says means an individual who intends the specified political subdivision to be his permanent resident and intends to return. So I can say, hey, I intend to move to Texas and be a resident, and there could be a court that says that's enough off this definition, correct?
Well, you have to show a home and a fixed place. If we're looking at the definition pursuant to the Election Code, which is what they've used in our current statute, then that can happen. However, there's a balancing test
Okay.
where the legal resident, if they say, I'm a legal resident under the definition, the defendant can say, well, I think you've alleged that in bad faith. Let's look at your legal residency.
So you're not concerned that this definition is overly broad? Because
Oh,
we-
I'm sorry, I misunderstood the question.
you're not concerned that this definition's overly broad right here?
Well, in what context?
In the context that someone can say, I intend to be a resident, and I have a mailbox in Texas, therefore I'm a Texas resident.
Well, I don't think it's overly broad to this extent. If there wasn't a bad faith provision where the court could make a finding by a preponderance of the evidence
Okay?
that this person is falsely or engaging in fraud or mischief and saying they're a legal resident, then I would say it's overly broad. But there's a bad faith provision
So you
where
think
that can be
striking the
attacked.
definition would be bad?
Striking the definition would be bad to this extent.
Okay, so what if we revise the definition?
Well, it depends on the revision, obviously, but hear me out just for a second,
Okay.
Representative. In terms of legal resident, when we talk about it, and I think you said, and correct me if I'm wrong, legal resident does not mean immigration status.
Right.
Legal resident talks about the political subdivision.
You can have a green card and be a resident of the state of Texas.
Correct. It really has to do with folks who are maybe in the military and go off to Iraq for 6 months and then come
And their
back.
residency is established.
Students abroad, well, college students, foreign service officers who may go away for 3 years, but Texas is their home. So in that regard, I don't think legal resident is broad.
And I would tell you that linking in the Service Member Civil Relief Act and other appropriate laws would make it very clear that those individuals are protected.
Right.
I mean, would you not agree? Because the federal courts and the Congress has made it very clear when you're talking about military members, for example, that they set out provisions for a member to be able to define what their residency is, and that's applicable to the states, is it not?
I don't disagree.
Okay.
But there's more than military. There's the college students, someone who may decide to go work in an oil rig in Louisiana.
And these aren't issues of first impression, are they? Courts deal with these all the time. They deal with them in 46 other jurisdictions plus the federal courts, correct?
That's correct.
Okay. And so you would agree with me that Texas is, as the previous witness stated, Texas has a very generous exception for their residents, do they not?
A very generous exception because when you say a very...
With forum non-convenes.
With forum non-convenes, but that is in part because of 71.031, which allows...
Right. And we
these
want to
class
keep
of
that.
persons. Correct.
We want to keep that, and that's the intent, is we want to keep that exception so that Texas residents, valid Texas residents, can continue to get the benefit of Texas courts.
Yes, sir.
What we don't want, and I don't care what the jurisdiction is, whether it's another state, another country, to me it doesn't matter. If an incident occurs in another state and you're using some indirect person to bring jurisdiction into Texas, that becomes problematic because you're utilizing our court systems to adjudicate something that should be adjudicated properly in another venue. Do you not agree with that?
It depends on the facts.
Okay.
I really think that each case is going to turn on its own
And
facts,
that's-
including in Ray Ford.
And that's what we're trying to do, is we are trying to give the judges some discretion and we're trying to get while maintaining our very generous exception for our own residents, but also get our statute a little bit more in line with everybody else. And at the same time, with all that said, I just want to thank you, by the way, and thank TTLA, because you guys have been working with me on this, and I hope we can continue to work together on this to come up with a solution. And even if we can't get to a full solution that makes everyone happy, I'm hoping we can get a bill passed that's all, because I legitimately believe that this is a problem, and I think NRA Ford is a good demonstration that we do have a problem, because we shouldn't have that dispute, with the exception of JT, the daughter, be adjudicated in Texas courts. Thank you, ma'am.
May I?
Any other questions?
Okay.
Did you want to, you had more
May I
testimony?
respond? Yes, I did.
Sure.
I did, okay. In terms of the NRA 4 case, and in terms of facts, because I think there was some questions raised about contacts with Texas and what really happened in the NRA Ford case, I think it's important to point out that Ford was attacking that there were intervening beneficiaries who were not plaintiffs. But Ford did not attack the legal residence of JT or the adult child who brought the personal representation, yet they had the opportunity to do so under that bad faith provision. And Ford did not do it, and the Supreme Court pointed that out. The Supreme Court also pointed out that the reading of plaintiff within the Ford case contorted the definition of plaintiff as it's known in the context of tort law, for example. And the bill as written has a definition of plaintiff that essentially closes the courthouse doors on a class of claimants, whether it's intervenors, whether it's next friends, where minor children wouldn't be able to bring forth a case if their father or their mother was killed. And those are some perhaps unintended consequences of the bill as it's written. So that's why I just wanted to briefly lay out the, in terms of NRA Ford, the facts of the case, where there had been allegations that there was maintenance of the vehicle in Texas, that several, Cesar, the deceased, had actually gone and had maintenance to the tire in Texas, that Ford had tested Explorer vehicles in Texas. So there were actually, it's in the NRA Ford opinion, that those were the allegations of contacts. So it wasn't that there was no contacts. There also was a, as was said, a Texas legal resident involved, but no one ever asked if the other ones were legal residents. And that's where there's somewhat of a flaw in saying that NRA Ford is the textbook case for saying we need a new statute. In terms of the other unintended consequences, which we would love to work with you on the language, is the definition of plaintiff. Because right now, as the bill is written, interveners, wrongful death beneficiaries, the next friends, and any other derivative party would not have a cause of action. A survival action brought by an estate, if they are not a legal resident, would also not be able to be brought forth in Texas. And perhaps the substituted bill has this in there, but at the moment, as the bill is written, Texas residents were subject to the savings clause, and under the bill as written, they are not. Now Texas residents, Texas families must prove their residency. They must prove that even if they were in college, they must come back under the bill as written and prove their residency. It also shifts the burden from the defendant to the plaintiff. The plaintiff must now prove significant connection to the state. So whereas Texas families were exempt, now they've got a burden. And so if there are 60 or so cases that are filed that may be Ford or maybe Cooper's, the bill as written impacts 27 million Texans. And Texas has an interest in protecting its families. It has an interest in providing residents with home state of living. and an interest in regulated companies who have such limits. So, and finally, with regard to the legal resident definition, there is having no definition leads to a misinterpretation by the courts of the legislative intent. And that is why a definition would be necessary, because it could also take us down a path where it becomes an immigration bill or there's constitutional issues, and that's something that we don't want. So many thanks again to Representative Sheets. If there's no more questions, then that concludes my testimony.
Any questions, members? Thank you very much.